Welcome back to Court TV. I'm Carol Randolph. His Native American name means man of dawn. But prosecutors in Ohio say 66-year-old Vernon Bellecourt shed more heat than light on an issue that has become an embarrassment for the city of Cleveland. That issue is the name of the local Major League Baseball team, the Cleveland Indians, and its mascot, Chief Wahoo. Now, Native American activist Bellecourt was accused of criminal endangerment when he set an effigy of Chief Wahoo on fire. He was also charged with resisting arrest when ballpark security forces moved to stop the protest. Well, Bellecourt cites his constitutional right to freedom of speech and assembly as his defense. And Court TV will continue with its coverage of Bellecourt's trial, heard earlier this month, right after this update on the latest legal news from Dan Broden. Dan?
Carol, a post.
Thanks, Dan, and we'll check back with you in just about an hour. Until then, Court TV continues with its coverage of this month's trial of Native American activist Vernon Bellecourt. Now, Shakespeare might have claimed that a rose by any other name would smell as sweet. But in the opinion of Bellecourt and two fellow protesters, the Cleveland baseball franchise's choice of name and logo has put the whole team in bad odor. Court TV's Michael Christian has this report on fan opinion about the character at the center of the storm in the case of Ohio versus Bellecourt, Chief Wahoo.
Actually, I understand where they're coming from. I sympathize with them. It's going to be awfully hard to change, though. They've had that emblem for 50-odd years.
I don't think there's any intention of being racist at all in this. It's just a sport, just a name.
Baseball is known as America's favorite pastime, but are some team names and mascots an insult to Native Americans?
I believe having the Indians' name on any team, they should be proud of it.
So it's not an insult, it's an honor?
I feel it's an honor.
Personally, I'm not offended by it, and in my opinion, it sort of celebrates the Native Americans, so I really don't have a problem with it at all.
But descendants of this country's earliest inhabitants say they have a problem with it. They regularly protest the Cleveland Indians for that team's use of a name Native Americans say belongs to them. Many Indians fans, however, disagree.
I don't think it's meant to degrade. I think it's meant to celebrate Ohio. Ohio is an Indian name.
It's recognizable all over the country. Actually, I think they're protesting for nothing.
Activists are especially upset about the Cleveland Indians' mascot, Chief Wahoo, a caricature Native Americans say they view as particularly repugnant, but some find endearing.
I don't think it's a racist symbol. Not at all. Actually, I think it's a wonderful symbol.
I can see where they're coming from. I understand being black and African American. Yeah, I do like the Indian logo, though.
For its part, Indians management dismisses any charges of racism. A team press release notes, "In no way do we intend to demean any group, especially one as proud as Native Americans." Team supporters tend to agree.
I don't think it's meant in any way as an insult, and in my eyes, it is an honor.
That's what identifies them. They've been around for so long, one of the initial teams, so I don't think they're going away.
Among baseball fans in Cleveland, one can hear differing points of view.
When all of these teams were put together, I don't think that they even thought of this ever happening, and I think that now that this being the 90s, they ought to revisit all of these little icons that they're using, because if it is actually causing a disturbance amongst the Native American community, then it warrants being looked into.
It's always been the Indians. It's our tradition. It's Cleveland. Everybody's known us as Cleveland, as the Indians. I think they should leave it as the way it is.
But at the bottom of the ninth, Indian fans may be more concerned with triumph than tradition.
If the Indians change their name, would you still be a fan?
Yeah, still Cleveland.
As long as they keep winning.
That's right.
Michael Christian, Court TV.
Well, let's go back into the courtroom to get to more testimony regarding individuals who felt they had a right to protest and did so. The next witness up is Todd Greathouse. He is the Site and Security Director, and he is asking a direct examination about the night of October the 23rd, exactly what he saw, especially as it relates to the effigy that was burned. Let's go in and watch.
I want to take you back to the date of October 23rd, 1997. Do you recall that date?
Yes.
Okay. And on that date, were you working?
Yes, I was.
Okay. Was there a ball game that night?
Yes, there was.
Okay. It was a World Series, in fact.
Yes.
Were you walking around the stadium that day like any other day?
Yes, I was.
Okay. Was there anything unusual, any scene where there's unusual circumstances to which you were called?
Yes.
Okay.
I was walking down Eagle Avenue at the time, And at roughly 6 o'clock, I got a call. My radio number is Unit 1. They called Unit 1 and said that we had...
Objection as to what the call was.
Okay.
You can't testify to what the call was about.
Right, I'm sorry. You don't want to talk about...
Keep your voice up, please. If you're gone over there, you can come on back over here, unless you need it.
Yeah, because there's specific things.
Okay.
I'll speak louder.
Please keep your voice up.
Yeah, make sure you're talking so they can hear you all the way against the wall there. Without getting specifics of the call, you responded to the scene in this area?
Yes, sir.
The grassy knoll area once again. What did you see when you arrived at that scene?
Actually, I responded to a call at Gate C, which is called Bob Feller Statue. And when I arrived at the scene, I saw that protesters were protesting at the time. I studied the surroundings, and I got on the radio to ballpark management, Jim Polk, and I asked him if he would send me 10 more police officers.
Why did you need more police officers?
I felt that at the time in that area we were outnumbered by the public and also the demonstrators. I could not handle it with the officers that I had at the time.
Okay. So they were in this area of the Bob Feller statue?
Yes.
Okay. And what happened after the officers arrived?
They helped. I asked our officers if we could ask the protesters to move to the grassy knoll.
Okay. Did they in fact move to the grassy knoll?
Yes, they did.
Okay. While they were on the grassy knoll, did you still have a view of them?
Yes, I did.
Okay. And what were they doing while they were on the grassy knoll?
They were protesting. I'm not sure.
How were they going about protesting?
It was okay for just talking to the public as they go by for 10 minutes, I would guess. And at that time, I stand back all the time. And on Eagle Street here, I was standing next to Jim Polk from Ballpark Management, and I noticed one of the protesters open up his coat and pull out something that looked like lighter fluid. So I mentioned to Jim Polk, I says, there may be a problem here.
Okay, did you continue to watch this individual?
Yes, I did.
And what did this individual do?
After maybe 5 minutes, the individual, again, reached down, lit the mannequin, if you will, and, put lighter fluid on the mannequin.
Okay.
And then a minute later, something like that, lit the mannequin.
Now, were you watching him this entire time?
Yes.
Was it the same individual who did all these acts?
Yes.
Did you know who this individual was?
Yes.
Who was that?
Bellecourt.
Okay, and this is the same Mr. Bellecourt. Do you see him here in the courtroom today?
Yes.
Okay. Can you just point him out real quick?
Right here.
Okay.
He's a point.
Okay. Your Honor, may the record reflect he is also identified as Mr. Bellecourt. Okay. After the effigy or the mannequin you called it went up in flames, what did you do?
At that time, I was looking for a water source to put the flame out. I felt that was part of my duty. And also I asked our off-duty police to have these protesters moved off our site for safety reasons.
Okay, and did you feel it was an unsafe situation?
Yes, I did.
Why?
In that area, which is the grassy knoll, there were containers, helium containers, and I felt that they would explode. I saw a lot of families walk by, and I feared myself to put as I was putting the fire out.
Okay, so you yourself participated in putting the fire out?
Yes, I did.
How did you go about doing that?
I went in that location there. We have a security system, a sprinkler system, and I reached down into a sprinkler box, and I turned the water on, then went over to an individual sprinkler head and used my thumb actually to get a fan of water, and it put the fire out.
How long did it take approximately to get the fire out?
3 to 4 minutes.
Okay.
Well, we have a bit of a break here at this point to introduce our new guest commentator. He's Trevor Gurrell, a very familiar face here at Court TV, former police officer, former prosecutor, now a criminal defense attorney, and once again, a pleasure to welcome you back.
My pleasure, Carol.
Let's talk first just on a societal issue, if you will. I've just looked at our little interview that we showed early on with Michael Christian. You don't get a lot of public indignation about this whole issue. A lot of people don't even understand what it is that Native Americans are complaining about. What's the big deal? And you and I were trying to, talking about that in terms of contrasting with the civil rights movement. Without that passion, I don't think things are going to change. Or do you disagree with that?
Things will not
Public
change
passion.
as quickly. I think you're absolutely right. There certainly is not as much passion. Perhaps it has to do with the fact that there are ties to slavery and all that this nation has experienced over 300 years that was associated with the African American, the so-called black movement of the 60s, where we were deprived of many different civil rights. We were unable to vote. We were unable to use certain public facilities. There was labeling of water fountains and bus stations, and in a bus you couldn't sit in the front, things of that nature. Those are strike a very strong emotional chord. I don't think that the same chords are being struck, certainly with the Native American movement. It's a little strange when you consider that much of their experience and much of the propaganda that's been passed around regarding the Native American should elicit similar responses. For instance, the old child's game of cowboy and Indians. Now, we all know that the cowboys were the good guys, because after all, they wore white hats. The Indians were always the bad guys. They went around scalping people. And interestingly enough, this was a worldwide phenomenon. Now, I grew up in the West Indies, in Jamaica, and back in Jamaica, we played cowboys and Indians too. And everybody wanted to be the cowboy. Nobody wanted to be the Indian. I mean, how did we get these notions? Well, certainly from film, because we have all been very much influenced by film in particular.
Well, given what you're saying then, too, the problem I would think would be selecting the jury that, number one, for each side. Here, for the Native Americans, this is free speech. This is passion. We are taking a stance because of how we feel. But on the other side, if you're less than sympathetic about it, the prosecution is saying trespassing, where you should being where you should not be, and doing what you should not be doing.
Well, Carol, I seem to recall those same arguments back in the 60s by Bull Connor, darn it, down in Alabama. By God. As a matter of fact, during that time I was a police officer, and I was torn asunder, because on the one hand I was supposed to be enforcing the law, but on the other hand I sympathized with what was taking place. Yeah, if we followed that logic to its so-called conclusion, there would be no such thing as an advancement in civil rights in this country. Lyndon Johnson would have not signed the civil rights bill. There would not have been equal rights for women. Not at all. No. As a matter of fact, I recall also, with respect to Chief Wahoo, those garden statues that people used to have on their lawns with little black Sambo. For the longest time, that was okay. Why are these Negroes putting up a fuss about that? Well, you no longer see too many of them, do you? Because it was distasteful. It was an insult, and this is what these Native Americans are trying to portray, tell the public.
And the public doesn't seem to get it yet.
Well, hopefully they will.
Well, you think they're
by golly.
You think they'll get to that point?
Bam! I think by God they will.
All right, we'll be right back with more. For the trial of Native American activist Vernon Bellecourt, arrested last October for criminal endangerment and resisting arrest during a protest outside the Cleveland Indians ballpark.
The symbol of Wahoo is one of the worst racial slurs that someone can use, and it's institutionalized into America's favorite pastime, baseball.
Welcome back to Court TV. I'm Carol Randolph. Native American protesters gathered on October 23, 1997 to dispute the use of a symbol. According to them, the Cleveland Indians baseball team's mascot is a biased representation and appropriation of Native American culture. The prosecution says those protesters damaged property and endangered bystanders during their demonstration. Let's go back into the courtroom for more testimony from this trial. Once again, we have an individual who was on the stand, Todd Greathouse, who was charged with the responsibility of security, and he continues to explain about the burning of the effigy.
Mr. Greathouse, going back to where the fire, where exactly was this effigy when it was burning?
It was in again, the grassy knoll at 9th and Eagle.
Okay. Was it suspended? Was it on the ground?
Suspended.
Okay. Where was it suspended from?
From a tree.
Okay. What happened to the tree while this incident was taking place?
It caught on fire, and I heard crackling noises, such as a wood on fire.
Okay, once again, you got to keep your voice up there.
Okay.
Yeah. Okay. Mr. Greathouse, I'm going to put in front of you what has been marked as Exhibit Plaintiff's Exhibits 2 and 3. Okay, can you take a look at those items? What is it that I put in front of you there?
Polaroid pictures of a maple tree that's burnt.
Okay, do you recognize?
Objection. He can't testify whether it's burned or not. He's not an expert.
Put a question to him along those lines.
I was getting to that point, John. I was going to get to that just yet. Mr. Greathouse, what is that a picture of that you have in front of you?
A tree.
Okay, is there anything unusual about this tree?
Objection.
Okay, repeat your question, I'm sorry.
Do you recognize those pictures that I placed in front of you?
Yes, I do.
Okay, do you know who took those photographs?
Yes, I do.
Who took those photographs?
I did.
Okay, and when were those photographs taken, sir?
Following day.
Okay, so if this incident took place on October 23rd, these photographs would have been taken on October 24th. Is that correct? Do you recall about what time of day that was?
No, I don't.
Okay. And sir, once again, you said these are pictures of the trees, tree?
Yes.
Okay, and just looking at those pictures right now, is that a fair and accurate representation of how that tree appeared the day you took the picture?
Yes, it is.
Okay. And sir, what is it, if anything, that's unusual about the tree?
I object, Your Honor. Proper foundation.
He can testify as to what he observes through the photographs.
What is it that you see? Looking at the first one, which would be on your left there, sir, what, if anything, do you notice that's unusual about that tree?
It's blackened.
Okay. Is the entire tree black or just a part of it?
A part of it.
Okay. What part of it is it that's blackened?
There's a branch off. There's a Y in the tree. It looks blackened.
Okay. What, looking at the next picture, Plaintiff's Exhibit number 3, what, if anything, is unusual about the tree there?
The same.
Okay. Once again, there's a blackening. And where is the blackening?
In the arch of the tree.
Okay. And once again, that is how that tree appeared the day after this incident.
Right.
Okay. Now, you, as the manager of the grounds, do you ever deal with trees and other such property?
Yes, I do.
Okay. Had you known of this tree prior to that day?
Yes.
Okay. Did it appear that way prior to October 23rd?
No, it didn't.
Okay. Did it appear that way prior to this incident taking place?
No, it didn't.
Okay. After the fire was put out, Mr. Greathouse, what happened next?
I made a decision to, again, to ask our officers to have the protesters moved onto city property.
Okay. And so by moving them onto city property, where are you moving them from?
From the grassy knoll.
Okay. And whose property is that, as far as your understanding?
Grassy knoll's Gateway's property.
Okay. To your knowledge, did they leave at that point?
Yes, they did.
Okay.
And you hear them say, whose property is that? Because one of the issues is, again, was it private or was it public? And you have a right to be on public land and make a have a peaceful demonstration, or if you will, but not on private without permission. And that brings up the point to a couple of points. Number one, Trevor, let's go into burning of the effigy there. Mr. Bellecourt says that's symbolic speech, First Amendment, protected by the First Amendment, and he likens it very much to the burning of the American flag. Now, it may cause a lot of people a lot of stress, but it's been upheld as being protected speech.
It most certainly has, Carol. As we know, the Supreme Court has said you certainly cannot yell fire in a crowded theater. That's a no-no. But this has been challenged and brought all the way up to the Supreme Court, as you said, and the Supreme Court has ruled that it is perfectly legitimate and lawful to burn the American flag. However, so the fire itself is not the issue. It's how that fire is used. Now, you can't just light an American flag, just say next to a gas station, and say, well, you know, the Supreme Court says I can light a flag. So, but no. So it all depends on the circumstances. In this particular instance, I believe. The prosecution alleges that there were some helium balloons nearby.
Nearby, yeah.
And so that constituted a possible danger. On the other hand, the defense has said that helium is a non-combustible gas, so there was no danger. So, you know, it really depends, on, I guess, to a great extent, on how you perceive and how you view things. How was this fire started, and who or what did it place in danger? Now, according to the language of the statute, if you place a person or property in danger, then you're violating the statute.
Well, you have the property is this tree.
Is this tree?
Yeah, right. Now Michael has said he viewed the tree. The branch may be gone forever, but the tree is still blossoming here.
So where's the damage? Are you going to prosecute someone? I mean, arrest them, jail them, and then take them to trial on the ground that a branch of a tree has been damaged? You know, that seems a bit of a stretch.
But if
However,
go ahead.
The interesting thing here is, had these Native Americans brought their own pole, let's say, and hung Chief Wahoo on this on this pole and then burned him in effigy, that would have been their property. So there would have been, you know, that was damaged.
Well, if it was their property, but they stuck it on this grassy knoll, will we still be talking about the issue of public versus private? Because that still is kind of, it's unclear here. This is a stadium that taxpayers' money may have gone into building the stadium. Certainly, there seems to be mixed in terms of who's patrolling the area. Private police, like this man here, this witness, but also you have police officers. Now, you have been a former police officer at one time or another. Did you ever do anything like this? Could you do anything like this?
No, I didn't. The term we use is moonlight.
Moonlight,
in that capacity. Now, in New York, under our jurisdiction, you are allowed to moonlight, provided you notify your captain, your superior officer, and that is okayed by the police commissioner. However, you cannot moonlight, you cannot work in an off-duty capacity wearing your uniform, not in New York. However, many jurisdictions do permit that. For instance, here in Cleveland. Sure. So now it's a very close question, and at some point it should be tested, I believe. I would think it would be all the way up to the Supreme Court, as to when a police officer wearing that uniform representing the state, the government, who's working in a private capacity, in an off-duty capacity, so when he's being paid by this private person, to whom does he owe allegiance at this point?
Well, not only that, but if you're sitting there looking at the police officer, are you going to think, oh, he's here in a private capacity, or he's here because he represents the city of Cleveland?
You certainly won't know.
You won't know. You'll be thinking Cleveland police officer.
Sure.
Well, we need to take a break at this point, but don't go away. More to come in this trial from Ohio.
You are aware that American Indians hate the logo, and a lot of Indian baseball fans love the logo.
I'm aware that there was a court order.
The New Orleans Saints, the Boston Celtics, the New York Knickerbockers, and the Mississippi Rebels. Just a few of the college and professional sport teams that use religious, ethnic, or regional symbols as mascots. Well, some Native Americans find the Cleveland Indians logo racist, and they staged a protest outside of Jacob Field during a World Series game last October. But when the protesters burned an effigy of Chief Wahoo, authorities on the scene arrested 3 Native Americans in the group. They were later charged with criminal endangerment, criminal trespass, and resisting arrest. Now, the defendants claim that they were within their First Amendment rights. As we go back into the courtroom, we're going to watch a videotape, and you should know that all demonstrations are videotaped. So this is nothing unusual. Just happened to have caught what happened that night, October 23rd, 1997. Let's watch.
Rise up in the stadium, Ohio cycle Indians cheering, leave it off, and throw them your love song. Good night, every day. Years ago, and you still wear the Make sure you get it. Wait this back to what? This thing is right here.
Show some dimensions here. This is where the fire was. This tree, as you can see, probably not more than 5 to 6 feet per second. Also very close to a stand here with the balloon.
Well, we have to take a break now, but stay with us. When we return, we'll have more from the video of the events in Cleveland the night Vernon Bellecourt was arrested.
Did anything unusual happen involving this effigy?
Yes, it was lit on fire.
Okay. Did you see this effigy being lit on fire?
Yes, sir, I did.
You personally observed it?
Yes, sir, I did.
Did you see who lit the fire?
Yes, sir, I did.
And who was that?
Vernon Bellecourt.
Were the actions of Vernon Bellecourt in October of 1997 a simple exercise of his right to free speech or an act of criminal endangerment? And that's what a jury in Cleveland had to decide when the Native American activist was tried earlier this month in Cleveland, Ohio. Well, just before the break, we were looking at a videotape of the demonstration that took place on October the 23rd. Now, we should say once again that the ballpark security forces videotaped all of the demonstrations, so there was nothing unusual in the fact that they were putting this on tape. But what was unusual was the burning of the effigy that we just saw that led to the arrest. And let's go back in to show you more of what happened on that night of October the 23rd. Let's watch.
The problem is in town. Okay, Cap. How far the captain is on the field? There is a big
Once again, there's this videotape, as we've indicated, that was shown in that courtroom. This videotaped demonstration is done every time there is a demonstration outside the ballpark. And when we're hearing some of the charges that these individuals are faced with, one of those is aggravated disorderly conduct. Now, if you say just in general disorderly conduct, I don't see aggravated disorderly conduct at all there. The videotapes often are used by the prosecution because it helps their case, but what did we see that helped the prosecution?
I didn't see anything, frankly, Carol. I didn't see any of the people who are going into the stadium being interfered with, and I didn't see their paths obstructed in any way. I saw people passing by, ignoring to a great extent the speakers.
To a great extent, to a large extent, yeah.
Occasionally there may have been some snickers, but you know there certainly wasn't any reaction. So where this aggravated disorderly conduct comes in, I don't know. I don't see it personally. No, I guess it all has to do with perception. You know, one's perception is one's reality. I think sometimes you see these charges being brought because the police officers, if they're going to place someone under arrest, they have to find some charges which to prefer against them. And they want to find the maximum charges under the law that's permissible. So.
Welcome back to Court TV. I'm Carol Randolph. Well, things got pretty heated in and around Jacobs Field in Cleveland on October 23, 1997. While the city's red-hot Major League Baseball team was inside the stadium getting ready for the third game of the World Series, Native American activist Vernon Bellecourt was outside the park burning the team's mascot in effigy. Now, park security sought to cool things down by dousing Chief Wahoo with a lawn sprinkler and arresting Bellecourt for criminal endangerment. But Bellecourt says those actions had an illegal chilling effect on the exercise of his First Amendment rights. Court TV will return to its coverage of Bellecourt's case right after this update on the latest legal news from Dan Broden. Dan? Court TV now resumes its coverage of the criminal endangerment trial of Vernon Bellecourt. The 66-year-old says he was just exercising his constitutionally guaranteed right to free speech when he lit an effigy of the Cleveland Indians mascot on fire. But Cleveland prosecutors say his actions constituted criminal endangerment of other people in the area, and they put Bellecourt and two other protesters on trial this month. Well, we've just seen the videotape that was done of that demonstration. They videotape all demonstrations outside that baseball park. And now we have Todd Greathouse. He was the one who introduced the tape. He is the chief of security there. He's now on the stand for cross-examination by defense attorney Terry Gilbert. Let's watch.
Is there a
a rule that says effigies cannot be burned on Gateway property?
No.
When you saw Mr. Bellecourt light the effigy?
Yes.
Do you know who Sergeant Sharon McKay is?
Yes, I do.
We just saw the video of that. Did you see Sergeant McKay grab the arm of Mr. Bellecourt?
I don't recall.
Did you see Mr. Bellecourt grab Sergeant McKay?
No.
During the entire period of time when the effigy was on fire, there was, you did say that there was a Pepsi guy there with a balloon.
Yes, I did.
Did he move at any time during the fire being burned?
I was concerned about the fire at the time.
Who was the guy, the Pepsi guy?
I have no idea.
You never got his name?
No.
And if, are you experienced in explosives?
No.
So you couldn't say what would happen if fire and helium mixed together, what would happen?
No.
If I told you that it is not combustible, how would you react to that?
I guess I need proof.
Yeah. And you were just making your job is to be overly concerned, right? Because you have, that's your job, right? Yes. And, but you really can't tell us what the actual threat would be of that dummy burning to the balloon, which was around 10 feet or 15 or 20 feet away. I can't tell from that video. You can't say what the actual threat is, can you?
I was concerned about the containers.
You can't testify as to what the actual threat would be to the containers. You saw, like we all saw, flames emerging from this effigy, is that right?
Yes.
And how many feet away were you from that burning?
15.
Can you say what was burning at the time that you saw the flames?
Could you say that again, please?
Can you actually say from 15 away what was burning?
Yes.
You can distinguish the burning of an effigy and the flames coming from the effigy versus burning from another object.
Only because I saw it.
Now, you took a picture of the tree the next day. What time did you take that picture?
I don't recall. It was a normal work day, so I normally come in at 9 o'clock.
The fact of the matter, the tree is alive and well and doing fine, right?
I'm not sure. I mean, it's blooming, yes.
It's blooming, it's flowery.
Right.
We have a nice early spring, and it's showing blossoms.
But I am a expert by, not tree expert, landscape expert by trade.
You are a landscaper?
Yes, I am.
Oh, okay. Who owns the tree, by the way?
The Gateway.
And does Gateway have a private tree service that it employs?
Yes.
Who's that?
Davy Tree.
They come out and take a look at the tree?
Yes, they did.
can't say whether there's any damage to the tree, can you? All you could say is you saw blackened area around some of the limbs, right?
Yes.
Anybody take a rag and try to wipe off the carbon to see if there was any damage underneath it?
No, I didn't.
Well, one of the charges, and once again, these are all misdemeanors, but one of the charges facing one of the defendants there is that of criminal damaging and endangerment, which the elements are that you can cause a substantial risk to physical harm to any property or another without his consent. But the property obviously is that tree. And once again, Trevor, we're back to something that we can't really answer, but is that tree on public or private land? And if it's private land, do we have a problem? If it's public land, what's the difference?
Well, you know, that's a very difficult question, and hopefully at some point it will be resolved. These ballparks, and we think we have the same phenomenon here in New York and across the country, really, where public monies are used, tax money from the people are used to construct these stadiums. Tax incentives are given to these owners. Now, you know, what type of property is this? Is this public property? Is it private property? If you say it's private property, then people turn around and say, well, hey, that's my tax money that's going towards the construction of these things, and you are getting particular benefits and incentives, tax incentives, as a result of my money. So now this should be, you know, public property. It's a difficult question. It's a hard question, but it's one I think that should be scrutinized and analyzed very carefully.
Well, I think you also have, because of their prior behavior, they had permitted 4 demonstrations, but this one was number 9. So then there's this doctrine of implied consent here.
Sure, particularly since they had allowed them to demonstrate, I believe, 9 times that month. So they hadn't stopped them before.
No.
Technically, they could have stopped them after 4 because by federal court order, they were entitled to have 4. But yes, there was certainly implied consent because they had 5 additional ones. What distinguished this demonstration from the others? Perhaps it was the burning of Chief Wahoo in effigy. Perhaps this is what really aroused the ire and disturbed the powers that be. Chief Wahoo should not be burned. Albeit in effigy, but he should not be burned. And what really was damaged here, Carol?
That's where we're back to that
branch. Yeah, because you do have to get back to that point.
But I have to tell you this: but let's take it out of the ballpark.
Sure.
Go to the other side.
Okay.
If, for example, that it was my tree, and the land or whatever it is was kind of in dispute, but it was my tree, I planted it and whatever else, I think I would be upset if a branch was burned or whatever else. If we kind of move into this, whether it's public or private, it just depends on what it is we're talking about.
Sure, and then the police officers would tell you that's a civil matter. You're going to have it resolved in civil court, Ms. Randolph, and then you have to seek your remedy in that way. But here you have the police officers under the guise of governmental authority. Remember, they're wearing the government
uniforms, right?
But who's paying them? At that particular time, they're actually off duty. They're not working as police officers, but then again they are. But then who's doing the compensation? The owners of the ballpark. So whose interests do they represent? The states or the private interests? Close question.
And because you mentioned the fact about the civil bit, too, we should indicate that there is going to be, it looks as though that whole issue may make its way into civil court to be resolved, maybe, maybe not. But it's interesting, too, in terms of we're saying that right to assemble and all, and how everybody sees this in different ways. We should mention the fact that for the defendants, this is a constitutional issue, and for the prosecution, it is not. We'll be right back with more from the trial of Vernon Bellecourt. And as we take a break, here's an update on some of the verdicts in cases Court TV has covered recently.
I believe that there are serious deficiencies in the presentation of the prosecution's case on each and every charge involved in this case.
Welcome back to Court TV. I'm Carol Randolph. Well, today we're bringing you a case from Ohio. 3 people of Native American descent protested against the Cleveland Indians baseball team. They claim the team insulted Native American culture by using an Indian caricature as their mascot and logo. Let's now hear more of the defense's motion for an acquittal.
Your Honor, at this time, we're prepared to argue our motions for judgment of acquittal pursuant to Rule 29C of the Ohio Rules of Criminal Procedure. I would say initially that It's going to take me a little while to go through this, so bear with me. I believe that this is a serious motion, not just a perfunctory attempt to get a charge dismissed on the record for appeal purposes. I believe that there are serious deficiencies in the presentation of the prosecution's case on each and every charge involved in this case. Just to go over the charges, and then I'll deal with each one specifically. Juanita Helfrey and Juan Reyna are charged with criminal trespass pursuant to the municipal ordinance. They're also charged with aggravated disorderly conduct pertaining to their behavior at the designated area on the Ontario side of the Gateway facility. Vernon Bellecourt is charged with criminal endangering and resisting arrest relating to the burning of the effigy on the designated area for demonstrations on East 9th Street. I would also say from the outset that all these charges have a direct implication on the First Amendment to the United States Constitution, that is the right to engage in free speech. So all these charges need to be viewed in that context and in the historical principles under the First Amendment that say very explicitly that before a criminal law or a statute can limit freedom of expression, the conduct must present a clear and present danger to persons or property. So that idea looms very large in this case, and I would hope the court considers that in rendering a decision on our Rule 29 motion. Let me first address the criminal trespass, because I think that is probably the clearest area where we have a grounds for motions for acquittal. As the court heard the testimony, there were two areas at the facility, two common areas accessible to the public and further designated as areas designed to permit demonstrations against the Chief Wahoo used by the Cleveland Indians baseball team. The two areas had historically been designated and I think indicates a privilege. Privilege is a significant element in the criminal trespass charge. The privilege was clearly extended to these demonstrators, to the defendants, and to others who wish to demonstrate peacefully against the Wahoo. Number one, they had every reason to expect that they could demonstrate in this area. In fact, as Sergeant Gonzalez testified to, the decision to allow the demonstrations was extended beyond the 4 days per month that was indicated in the court order that was introduced into evidence in this case. A court order that was agreed to by certain parties, but not all demonstrators, in Judge Manos's courtroom. And that order dealt with time, place, and manner, but the people involved in making decisions regarding this property, and I'll get into that in a minute, whoever that may be, clearly waived and released the provisions of that order by extending it to up to 9 protests that month. So the order, in a sense, is irrelevant to this case because its very terms were ignored and actually deviated from by those who are prosecuting this case, those who had initiated the charges. So number one, the the idea of being at the Ontario side was expected by the defendants. They believed they had a right to be there. And that belief is supported by the fact that personnel was enlisted, including peacekeepers, to be present that evening. So even the other side in this case, whether it be Gateway, the Economic Development Corporation, Ballpark Management Company, Tenable Security, they basically had hired people and scheduled people to work that night for the purpose of providing security specifically for the demonstrations. We have evidence that 8 to 10 officers were scheduled that evening to protect the protesters. So there's no question that the people involved in this case, my clients and the people who were at the Ontario side, had every reason to believe that they had a privilege. And that privilege under 2901.01 is defined as an immunity, license, or right conferred by law or bestowed by express or implied grant or arising out of status, position, office, or relationship. There was clearly a grant, whether implied or express, bestowed upon these defendants to be there, to engage in assembly, to express their opinions, to be verbal, and to show signs, and to engage in traditional free speech behavior. And as far as the court order is concerned, we have heard testimony by Sergeant McKay, who finally admitted, after being pressed repeatedly by my cross-examination, that the court order had nothing to do with her decision to order the demonstrators to leave the area near the Twin Towers. Now, here's where the alleged justification comes in. There was a discretionary decision by 2 individuals who were operating as paid employees of a private security company who received no authority, and there's been no testimony as to any authority granted to them by any representatives of the owners of Gateway Economic Development Corporation. No express authority given to them to make the decision to limit free speech. And these two individuals, Gonzalez and McKay, took it upon themselves, the off-duty police officers working for a private security firm, to suspend that privilege. And the reason for suspending the privilege was not because of any court order, or was because of some kind of ambiguous worry that something in the future may happen. But as I pressed them repeatedly, there was no testimony of any violence or turbulent behavior, any kind of activity that under the First Amendment would justify curtailing that right. There was no evidence of unprotected conduct. And this effort to remove the demonstrators was completely unjustifiable, because all the people were doing there were vigorously protesting. And there were plenty of police officers there, purposely there, to protect them to do that. Yet Gonzalez and McKay, for reasons that are still not very clear in this trial, and the only thing I can think of is to looking at the evidence favorable to them, is that because an effigy was burned on the other side of the 29 or 30 acre facility earlier that evening, that somehow that problem would carry over to here, but there was no evidence of that. In fact, the court purposely asked one of the witnesses, were there two distinct areas where demonstrations were going on simultaneously? And the answer was yes. So there was no reason for the arrest. There was no improper behavior. There was no clear and present danger of any harm or any danger to anyone. And the only reason that they limited the protest was because of their worry that it may, at some future point, get out of hand. But there was just no evidence of that.
Well, we're going to take a commercial break, but stay tuned for more of the trial of Vernon Bellecourt.
Medgar Evers and many known and unknown people throughout the age.
The symbol of Wahoo is one of the worst racial slurs that someone can use, and it's institutionalized into America's favorite pastime, baseball.
Well, that's Vernon Bellecourt's opinion of the Cleveland baseball team's mascot. But did he and several other protesters go too far in expressing that opinion last October? And welcome back to Court TV. I'm Carol Randolph. Well, Bellecourt and two other Native Americans were arrested outside of Jacobs Field after burning an effigy of Chief Wahoo, a logo they say is racist. The protesters were charged with various crimes, including criminal trespass and resisting arrest. And the defendants say, though, that they were within their First Amendment rights. Let's go back into the courtroom now as defense attorney Terry Gilbert continues to argue for a judgment of acquittal.
Resisting arrest requires more than just a jerking reaction when somebody, a police officer grabs you and puts your hands around your back to put handcuffs on. The court, I'm sure, has considered many resisting arrest charges, but I think the most important testimony in this case was from the man who actually arrested Mr. Bellecourt, and that is Curtis Harris, who was ordered by Sharon McKay to make the arrest. And that's an interesting point because he didn't necessarily react to the effigy. He reacted to an order from Sharon McKay to go arrest him. If it was so offensive, he should have on his own ran and arrested Mr. Bellecourt, but he had to be ordered to make the arrest. That's a minor point, but I wanted to raise that. But he said that Mr. Bellecourt simply did what was natural, and that was to briefly jerk away. But once he had the handcuffs on, there was no problem. And the whole thing, and then for 20 to 30 seconds, he was just shouting. And you saw that on the tape. I don't believe that that is resisting arrest, unless you try to make some kind of hyper-technical argument that any movement or any jerking is a resisting arrest. I don't believe that's what the legislature or the city council had in mind when it passed this ordinance. I believe they were talking about people who clearly and vigorously fight off efforts to put them under arrest. And that's simply not the case here. Mr. Bellecourt is a 66-year-old man with a heart condition. Any physical challenge to him creates a nervousness on his part, a reaction on his part, and just the slight jerking was certainly reasonable and not contemplated by the law. And once his hands were placed behind his back, you didn't see him trying to run away or fighting off the police. It simply didn't. He stayed on his feet. There were more than enough officers to effectuate the arrest. And I just think that this is a very, this is overkill. charging him with the resisting arrest. In fact, the whole case is overkill. We've been here for 4 days on a situation that never should have happened to begin with. These people had every right to engage in their free speech activities, and the whole apparatus of Gateway was geared up for this. They had lines, they had peacekeepers, they had security guards, they had off-duty police officers in both locations. And because something was burned, they were going to put an end to it all. And we live in a time of intolerance in America. And it would serve us all well if we start to think about what our cherished rights are. And that's why we have courts. We have police officers who think they're doing their job, who make discretionary split-second decisions in the heat of the moment. And then we have the ability in a courtroom to calmly reflect on what happened that day. And what happened that day was just a complete abomination and an abuse of discretion by 2 off-duty police officers who had absolutely no authority and no right to limit First Amendment expressions. So we would ask the court to dismiss all of these charges. Thank you very much.
Now, if you're a regular watcher of Court TV, you know that at the end of the prosecution's case that it's not uncommon for the defense attorneys to stand up and make either a motion for a directed verdict or, in this instance, motion for acquittal. Same thing, just terms may differ in terms of where we are, what jurisdiction we're in at that particular point in time. But here you have Mr. Gilbert going through some really intricate arguments here, taking some time here, because he honestly believes that the prosecution has a problem. So what are the elements that would normally give the judge the opportunity, if you will, to rule in favor of a motion for a directed verdict or acquittal here?
Well, very quickly, Carol, if the prosecution has failed to meet their burden of proving beyond a reasonable doubt the language of a statute, failing to show that may I just very quickly? Absolutely. That Vernon Bellecourt did cause or create a substantial risk of physical harm. Knowingly, did he do so by means of fire? Did he recklessly, again, as I said, by means of fire, do any of this, commit any of these actions? And also, in terms of the criminal trespass, was there trespass by Raina that without privilege, did she knowingly enter or remain on the land or premises of another? See, this is where that close question comes in as to whether this is private or public property. And as to the aggravated disorderly conduct, I've got to read this language for you, Carol. It says, did recklessly cause inconvenience, annoyance, or alarm to another by engaging in fighting, in threatening harm to persons or property. Now, certainly, by my view of the evidence that's presented in court, I don't. Right. Certainly, when you look at the videotape, that certainly supports, at least my view of it, that the prosecution did not meet their burden of proving beyond a reasonable doubt. And I think that videotape that was presented by the prosecution certainly illustrates this, and certainly the defense counsel, I believe, made an excellent argument in this particular instance, and the judge has the right within her authority to rule in support of the defense.
Well, Mr. Gonzalez, who was the first witness called by the prosecution, who was actually the person who made the charges against the 3 individuals, when asked about the fighting, well, who were they fighting with? Could not really give an answer on that.
Because there was no fighting.
Well, when he also said, well, there were threats made. Well, what types of threats and to whom? Well, there was a lot of shouting and so forth. Well, this was, of course, a demonstration. Was anybody actually threatening, I'm going to do such and such a thing to you if you don't do such and such a thing, which is what we normally think of as a threat? He couldn't even respond to that. So you do have problems for the prosecution right there.
Certainly. As a matter of fact, Carol, what I seem to recall, the only thing I could remember hearing loudly was, no justice, no peace.
No peace.
No justice, no peace. And passers-by were just passing by and ignoring the people who were using the loudspeaker, the people who were obviously involved as protesters. They were just ignoring them. So where were they interfered with?
And Mr. Mr. Gilbert is using also the language that we normally hear where constitutional issues come into play, clear and present danger. Where was that in terms of the property or the individuals? And again, back to where we were talking earlier, too, about the commonality of access, if you will, that where is the trespass here if everybody thought either by permission or by design that they had a right to be there? Trespass means that you knowingly do something wrong. If you thought you were right and had been given the right to be there by implied consent or whatever, were you trespassing?
Well, and obviously this is not the case here because these protesters were allowed to come on this property by federal court order, and they had done so. They were permitted to come do so at least 4 times per month. They were allowed 9 times this month. So where is there a trespass in this instance? And getting back to the clear and present danger, I presume that the prosecution hung their thesis on the fact that there was helium balloons near where the effigy was burning.
And you could see that.
You could see that clearly. Yeah. However, if helium is a non-combustible element, then where is the danger there?
Well, we've given the defense's side. Obviously, there's another side to it.
Well, there certainly is the other side, and that is, that they were causing inconvenience. They were
hold that
disrupting.
point. We're going to let the prosecution give his point of that. Does that work for you?
It certainly does.
Okay.
Let's do it, Carol.
We'll have to take a break at this point. The defendants think the charges against them should be dropped, and when we return, the prosecution, Reuben Shepard, will tell the judge why she should deny the motion. Stay with us.
Is there a rule that says effigies cannot be burned on Gateway property?
No.
And welcome back to Court TV. I'm Carol Randolph. On October of 1997, 3 Native Americans protested against the Cleveland Indians baseball team during a home game at Jacobs Field. They were arrested and charged with criminal damaging and endangering, resisting arrest, and disorderly conduct. Let's now listen to the prosecutor's argument of why the defendants were charged with disorderly conduct.
I think the first point that's absolutely critical in this case, and that Mr. Gilbert has seemed to really take steps to try to avoid here, is the fact that this was not a series of events. This was one incident that started on the East 9th side and carried over onto the Ontario side of the building. Just before I get into the specifics of the case, we know that these police officers and others testified to seeing all 3 of the defendants on the East 9th side of the building at the time that the fire was lit. It was at that point that they made the decision that this had to end, and I'll get into that in a little more in just a minute. But the point is that at that point they made the determination that they needed to end this demonstration because it was no longer a peaceful demonstration. It was at that point that Mr. Raina and Ms. Helfrey were told that they had to leave the property. Now, when they chose not to leave the property and they came to the other side of the building, they were already in contravention of a direct order of the police department. Furthermore, they were given several more orders before an arrest was effectuated. So in order for Mr. Gilbert to try to split up these 2 incidents, or turn it into 2 different incidents, he's ignoring the simple fact that this all happened in a very short period of time, and it happened over the course of a small area in a time when these officers had given them a direct order. From the beginning to the end, there were direct orders given. Now, like I said, I'll come back to those a little bit more in a minute. But going back, I think we need to, Mr. Gilbert kind of started from the back end and worked forward. I'm going to start from the forward end and then go to the back. I think, first of all, in dealing with Mr. Bellecourt's case, Mr. Bellecourt was involved in this first incident with the lighting of the effigy. And Mr. Gilbert gave several arguments and reasons why this is not a dangerous situation and why he believes no damage was caused. There's nothing in this statute, nothing in this ordinance, which states how great the damage has to be, that says a tree has to be killed in order for it to be damaged. There's nothing along those lines. What the ordinance simply says is that no person shall cause damage to the property of another. And in this case, clearly damage was caused. The evidence was presented by Mr. Greathouse, who is the one who's responsible for all of these, all the property that was damaged in the Gateway area. Photographs were presented which clearly show that this tree the coloration was changed. It was a whitish tree before the fire started. After the fire started, it was blackened. Leaves were burned. Mr. Greathouse gave very specific and descriptive testimony to that regard, and the pictures clearly bear out what he said. Damage was caused to this tree. Fortunately, the tree survived, as Mr. Gilbert said, but that in no way changes the fact that damage was caused. There is absolutely nothing which says what the threshold of damage is. It merely says no damage shall be caused. Furthermore, as far as the substantial risk factor is concerned, Mr. Gilbert continues to say that nobody came out and directly said exactly what the threat would be of having these helium tanks right there. And I would do exactly what he said I would do, which is to rely on common sense, which is something that we need to do in the courtroom. Common sense says that helium tanks with in these gas-type containers near a fire is a bad thing. It creates a risk of damage to the property in the whole surrounding area. And really, all these trees, all the lawn, everything in that area is property that belongs to someone else. It does not belong to Mr. Bellecourt. It's not his decision to determine whether or not that property can or cannot be destroyed. Nobody has presented him with permission to destroy this property. By setting this fire near the helium tanks, he created the danger, the substantial risk of danger, that damage would be caused to all the property area, not just to the tree, which was in fact already damaged. Furthermore, in dealing with the resisting arrest charge, Mr. Gilbert picked the parts of Officer Miller's testimony that he liked and kind of ignored the parts of Officer Miller's testimony that he didn't like. Officer Miller clearly stated that this struggle went on for about 20 or 30 seconds. Although the videotape doesn't bear out, I think, the entire 20 or 30 seconds, it's pretty close to that. To characterize Mr. Bellecourt's actions at that time as a natural jerking reaction is just a complete mischaracterization on Mr. Gilbert's part. Clearly in the videotape it shows that Mr. Bellecourt is moving aggressively back towards the tree where the effigy is hanging, even after he's been told he's under arrest. Mr. Bellecourt struggles with the officer. He doesn't just jerk. He struggles, he pulls, he creates a situation. I wouldn't take it to the level of being a fight, but I would certainly say that he was not assisting in the arrest. In fact, he was interfering with his own arrest at that point. He clearly was creating a situation where he did not want to be arrested, and he was not going to allow himself to be arrested until the effigy had served its purpose, until he had the opportunity to shout out all the different rallying cries he wanted to shout out, and until he got his mission accomplished. So he did not go peacefully, and he did, in fact, interfere with his arrest. It's clearly, once again, borne out by the videotape. Now, once again, as we've heard, it was at this point that the officers made the determination that this demonstration had to stop. It was time for this to end. The reason being, although the word peaceful does not appear in the court order, the reason being is that this was no longer a peaceful demonstration. At this point, Mr. Bellecourt had clearly displayed for everyone to see that this was going to be a demonstration that was meant to be shocking, that was meant to create fear and panic in the crowd, and I believe one of our people who testified did specifically say that a panic was caused. But what happened at that point was a determination was made that it was time for this demonstration to end. I think another point that's interesting here, Mr. Gilbert has decided that, they've waived the court order, but at the same time he's relying on the court order. It seems as though he's kind of torn in how he's going to use this court order. He says on the one hand, well, they're in this designated area that the court order specifically gave to them, but on the other hand he's saying, well, they can't enforce the other end of it because they've waived it at this time, because they've allowed Mr. Bellecourt and the other members of the American Indian Movement and the 500 Years organization, they've permitted them to protest beyond the 4 times a month. So it seems as though there's a conflict here in what Mr. Gilbert believes in regards to whether or not this order is still in effect. However, it was at this time, in the 9th time this month, that these people were demonstrating that the officers determined this is not peaceful. This is something that not just by court order, but as police officers, we know it's time to bring this to an end. They specifically give the order for all demonstrators to leave. The demonstrators made the decision themselves not to leave at this point. They chose to walk around to the other side of the building, and by demonstrators now I'm specifically referring to Ms. Helfrey and Mr. Raina. They walk around to the other side of the building and began doing just what they were doing on the other side, yelling, creating a disturbance by trying to yell at passersby, creating alarm and annoyance certainly to anybody who's trying to get past them. Completely ignoring the orders of the police department, who felt as though this situation for the public safety and for the safety of everybody involved needed to end.
Well, there you heard the prosecution arguing against this motion for acquittal or directed verdict here. Trevor, you'll be leaving me shortly, so let me give you a chance to kind of give your observations about this case up to this point.
Well, it's a little sad to see that things have come to this point, but sometimes it is necessary to proceed in this fashion.
Sad from being arrested, or sad that we have this type of situation where we're insensitive to what's going on?
Both.
Okay. Okay.
That's easy.
All right.
That's easy. Being African American myself, I can certainly identify with the Native Americans' arguments here. On the other hand, I can appreciate the other side, but my leaning is more toward the Native American side because I understand the impact and the symbolism of what's taking place. I made reference before to the garden statues of Little Black Sambo. We don't see that anymore. I think to a great extent we shouldn't see anymore of this Chief Wahoo nonsense. I think it's demeaning, and I do believe that in spite of this prosecutor's arguments, that if I were the judge, I would certainly grant the defense motion for acquittal. I did not see anyone being interfered with. I did not see anyone threatened, harmed in any way. The only harm I saw here was to the branch of a tree, because as has been brought into evidence in the court, the tree on which the effigy hung, on which it was set on fire, is still blossoming forth. Only perhaps the one branch has been damaged. So on that basis, I could not see finding these three individuals guilty, fining them $750 and possible 90-day sentence in jail. I think that's a bit of a stretch.
Well, what is it? Let freedom ring here.
Let freedom ring. Amen.
Right. All right, Trevor. Always a pleasure.
My pleasure, Carol.
And we're going to take a break, and when we come back, we'll have more on the case. We'll hear from the judge, so don't go away. Michael Christian will be joining me.
Tonight on Prime Time.
Welcome back to Court TV. I'm Carol Randolph, and now we're down to the wire. The defense has argued for a directed verdict, saying that the prosecution has not proven its case in the case of Ohio versus Vernon Bellecourt and all. However, the prosecution said, Judge, we did. They should have been arrested, and we have proven our case. It should go to the jury, but let's find out now how the judge decided. Let's watch.
All right, the court is prepared to address the motion pursuant to Rule 29, and I will do so in beginning with the case of the City of Cleveland versus Juanita Helfrey. Ms. Helfrey is charged with aggravated disorderly conduct and criminal trespass. In order for this case to continue, the evidence presented thus far must be sufficient to sustain a conviction for those offenses. It's this court's decision that such evidence has not been produced and that nothing in Ms. Helfrey's behavior on October 23, 1997 rose to a level of aggravated disorderly conduct or criminal trespass. As to the criminal trespass, specifically it must be shown that Ms. Helfrey remained on the land of another without privilege to do so. The evidence thus far presented has established a clear right to be on the land of Jacobs Field, and specifically the designated protest areas where Ms. Helfrey remained. The motion pursuant to Rule 29 is granted as to the defendant, Ms. Helfrey, as to both charges. Clearly, the evidence that was produced from the witness stand as well as the tape showed no activity whatsoever on her behalf that could rise to any level of inappropriate or illegal conduct under the codified ordinances of the City of Cleveland. Similarly, Juan Reyna is also charged with aggravated disorderly conduct and criminal trespass. Addressing the criminal trespass charge first, the same reasoning applies. Mr. Reyna was in a court-designated protest area and therefore met the element of privilege required for him to remain on that land. Nothing in Mr. Reyna's behavior rose to a level of aggravated disorderly conduct either under the law. His actions on that day were that he was participating in a protest, which is recognized protected activity. At no time did his personal behavior rise to a level which violated any codified ordinance of the City of Cleveland. On the tape, it showed Mr. Reyna sitting down when he was surrounded by police officers. At that point, that does not rise to aggravated disorderly conduct, and nothing prior to that There was no testimony prior to that event nor surrounding that event, which leads this court to believe that either Mr. Reyna or Ms. Halfrey engaged in violent or turbulent behavior or persisted in such after a reasonable request to desist. That is the key here, is that, first of all, the behavior has to have rose to the level of violent or turbulent behavior, if not engaging in fighting, threatening harm to persons or property, and persisted after a reasonable request to desist. Simply because the police, acting in their capacity as private security, requested that the protesters leave the grounds does not mean that the behavior prior to the request for them to leave rose to a level of aggravated disorderly conduct. There has been no evidence presented on as to Ms. Halfrey or Mr. Reyna's behavior up to that point. And again, they were protesting peacefully, this court believes, in protected areas. They remained in the areas. There were 2 protests going on. The tape clearly showed that there was nothing significant about the protest, especially on the Ontario side, which is when they were arrested, which could have risen to the level of illegal behavior. In fact, there was another individual who was making a lot more noise, who the court notes was not arrested. Finally, we reached Mr. Bellecourt. At this point, I'd like to add that it's not the function of this court to comment on the appropriateness of burning a Wahoo in effigy, or the likelihood that if it happens again, an arrest will probably occur. The only duty that this court has at this point in the proceedings is to determine whether or not sufficient evidence has been brought forth to sustain a conviction for criminal endangering, as well as resisting arrest. The city must show that the behavior of the accused caused or created a substantial risk of physical harm to any property. In this case, obviously, the alleged risk of harm would have been to the tree. The evidence deduced thus far has not shown any damage to the tree other than a blackening of the branches, which has not resulted in any actual damage to the tree. Again, the wisdom of the burning of the effigy is not the issue in this case for me to decide. The possibilities for things to go very wrong are very real, particularly in an area where there's thousands of people passing. But that's not the situation that we faced in this case. In this case, the protected activity took place within a designated area and ultimately resulted in no physical damage to the tree. To allow the case to continue on the supposition that some harm could have occurred would not be responsible when we know for a fact that no damage has occurred. The motion pursuant to Rule 29 is granted as to Mr. Bellecourt on the criminal damaging and endangering count. Finally, Mr. Bellecourt is accused of resisting arrest. The tape clearly showed that Mr. Bellecourt was being surrounded by several officers, and there was much grabbing at his person. The tape also shows his compliance with the efforts to place him under arrest almost immediately after he was approached. His initial reaction does not rise to a level of resisting arrest, and to suggest otherwise is to do a disservice to all of the officers who are seriously resisted on an almost daily basis in this city in their attempts to arrest. What is also clear to this court is that the police acted in their capacity in a way which they believed was appropriate under the circumstances in effecting these arrests. I'd also like to add for the record that the court notes that this case was extremely well presented, and that a ruling granting the defendant's motion pursuant to Rule 29 is not a reflection on the presentation of the case on the part of the city, but rather is my responsibility under the law to rule on the evidence as it is presented thus far. So the motion pursuant to Rule 29 is granted as to each count as to each defendant. Thank you.
As you can see their reaction, there was perhaps another reaction from Prosecutor Reuben Shepard, and Michael Christian got a chance to ask him about how he felt about the judge's ruling.
Well,
obviously I'm disappointed in it. I can't say that I completely agree with everything that she saw, but I respect Judge Keough and I respect her decisions. It's not how I would have ruled on it, but I can see where her basis lies.
Was this an unexpected decision, or did you think that maybe this would happen?
I would say it was unexpected. I was expecting it at least to go to the jury, but once again, I respect Judge Keough's decision.
Give me your reaction to Judge Keough's decision.
Well, a little bit of relief because the trial's over, but a little bit of disappointment. I really had thought that there's issues besides just the First Amendment issue, and I thought that there needs to be some accountability for breaking the laws of the city of Cleveland, and that's my job, is to sort of enforce those laws, and I think that's what we lose out on here.
There was some speculation among some of the court watchers that maybe the videotape that you introduced in your case may have hurt you more than helped you. Do you have any reaction to that?
My reaction to that is that I'm a prosecutor, and my job is to present the truth, and to pretend like a videotape doesn't exist or to not put it into evidence is ignoring the realities of the case. I interpret the video a little differently than I think some people do. I saw some things that I think other people didn't see. But at the same time, to pretend like it's not there, that would be dishonest. A prosecutor's job isn't just to get convictions. A prosecutor's job is to present the truth. I think that was necessary to do that.
And Michael Christian is back with us in the studio. Michael, first of all, let's just talk about how long it took the judge to reach this decision.
It was just a little over half an hour, Carol. She heard arguments from both sides. She heard a little bit of defense rebuttal, which we didn't show. She took her notes, which she had made throughout the trial. She also took a copy of the videotape back to her chambers with her and came back about 35 minutes later.
And I was listening to the prosecution there where they're talking about her interpretation, where there are reasons where you can come up with different views there, you go with reasonable doubt. But she tailored that particular decision to the law. Let's kind of walk through that.
Well, she seemed to. This is a pretty specific ruling. Again, the defense would love some pronouncements on free speech here. I don't think we got that. She says specifically in her ruling the correctness of burning the effigy is not something that I can comment on. But she honed in on, were they resisting arrest? Were they trespassing? Was there damage that did indeed occur? And on those issues, she found that the prosecution just hadn't proven enough to hold these defendants over, even to a defense case, let alone a verdict from a jury.
And you and I were talking earlier that you had the opportunity to go back. I mean, when we're talking about damage here, we were talking about a tree, and you saw little to no damage on the tree.
I mean, there is some. You can see in the videotape of the burning that clearly one branch is flaring up there. The tree is alive. The tree is budding. The tree seems now 5-6 months later to be doing okay. But there definitely is a branch that appears to be dead. I don't think that particular branch is ever going to bud again. So I think there's something for both sides. Yes, the tree is alive, but yes, there has been some damage there.
Well, there's a more reaction to all of this. We're going to take a break. We'll come back with that and some final thoughts again about this most interesting trial. Stay with us.
There's nothing like the feeling of a new car.
Within their rights, the night they burned an effigy of the Cleveland Indians mascot. Well, Judge Kathleen Keough said they were and dismissed the charges against the defendants. And afterwards, Vernon Bellecourt and defense attorney Terry Gilbert had this reaction.
Could I have your reaction to Judge Keough's decision?
Well, of course, everyone is really elated by it, and I think it's a victory for constitutional rights of free expression that we can never allow to be stifled in this country. If we allow that to be stifled, what other freedoms are we going to lose? So for that reason, we feel that the judge made a good decision. The burden of proof was up to the prosecution. They didn't meet that burden, and we were very pleased that she's seen it that way and dismissed the charges.
Yeah, what the judge's decision says is that free speech is alive and well in America, even in the face of great adversity from time to time, and she upheld the principle, which we applaud her for. This case was as much about free speech as it was about racism, because we felt it was incumbent upon our side to re-educate the jury and the public as to how awful these racial stereotypes are, and to remind everybody out there that we will not tolerate this. And I think we had a victory on both fronts.
These kinds of motions to dismiss are routinely made, and they're routinely denied by judges. Were you surprised by Judge Keough's decision?
I was confident about the trespass charges and the aggravated disorderly conduct charges. I wasn't sure how she would roll on the burning of the effigy because people aren't used to that in this, that activity, and it is somewhat shocking to see something go up in flames. So I wasn't sure how she was going to read that, but she obviously agreed with the proposition that burning American flag is protected conduct, so would burning any symbol, and unless that conduct rises to a level of clear and present danger to persons or property, it has to be protected. And there was no evidence in this case that indicated substantial risk to any property, and certainly there was no evidence that the tree was damaged. So I think that she did the right thing. I give her a lot of credit. It does take courage for judges to throw a case out before it gets to a jury, but she had no choice. I mean, that was her job, and she did it, and did it properly.
We know that Cleveland people are very emotionally attached to their logo and to the team name. And so we were starting from zero and having to get the jurors to understand that this case is bigger, larger than any trespass or any burning of effigy. And of course, we intend to continue this activity at Richard Jacobs Field on Friday to continue drawing attention to the fact that, in a way, we could start a Free Cleveland campaign because we're going to really free them of this institutionalized racism in baseball.
We should mention, too, Michael, that Mr. Bellecourt, they saw throughout, he was representing himself, but Mr. Gilbert also included him quite a bit in a lot of things in that courtroom.
It was an interesting
Arguments
relationship.
Yeah.
Mr. Bellecourt chose to represent himself, which is fine, and he certainly had a right to do that. Mr. Gilbert technically represented only Juan Reyna and Juanita Helpry, but because of the fact that Mr. Bellecourt is not an attorney, Judge Keogh gave Mr. Gilbert a lot of leeway to step in and help. Also, Judge Keogh gave Mr. Bellecourt a lot of leeway in his questioning. And I have to say, Mr. Bellecourt did a pretty good job. There were times when there would be objections to questions that he asked. Judge Keogh would sustain that objection. And Mr. Bellecourt pretty much caught on to what he couldn't ask, how he could ask it, would rephrase things. Didn't seem to be at loss, as a lot of defendants are, I think, when they try and act as their own attorneys.
Well, maybe he's getting a lot of practice because that was the first of many protests, apparently, because right after that, there was another protest that occurred later on. Let's go to show our viewers a little bit of that, too.
We just need to say when we get out of this. You notice they're not in the trees this time.
Well, now, Michael, what about how long after the trial ended did this occur?
3 days.
3 days after this? And where was this?
This is near Jacobs Field. It's in an area called the Ontario Street side. It's one of the authorized protest sections. And this was 3 days afterwards on the 10th, last Friday, and 5 people in total were arrested.
And the charges against these 5 were?
Have not yet been actually set, Carol. All 5 people were arrested, including Juan Reyna and Vernon Bellecourt. They were held overnight, but they were released the following day on Saturday. They have not officially been charged yet by the city of Cleveland.
Well, we're watching them being arrested. I don't see anybody resisting any of this. Again, we have the effigy, which was raised once before, on a pole and not on a tree here.
That's right. That takes away, I believe, the damage issue. Also, it's interesting, I've been told that they actually burned 2 effigies. One effigy represented Chief Wahoo, as before, and the other, which may be the one that we actually saw, I believe was meant to represent either the mayor of Cleveland, Michael White, and or Richard Jacobs, the owner of the Indians team.
Well, it seems that this will be, as we said, obviously this has been going on before. It may have escalated in terms of the burning of the effigy, but supporters in and out of the courtroom, what about that?
The courtroom was packed during this trial. There were most days standing room only. People were very involved, certainly more people who were supporting the protesters showed up, but there were a few people who came having to do with the police side. In fact, I think, for example, Sergeant McKay came back after she had testified to see how things were going. So it was a packed courtroom every day.
Michael, as always, a pleasure working with you.
Thank you.
I understand you're off on the road starting Monday.
Again.
Yes, and I'll be on the road.
I'll bring you another one.
I'll be on the road with your turn for
Good.
about 2 weeks. But that's all the time I have with you tonight. But thanks for watching the trial with me. Also, my thanks to Trevor Gurrell and certainly to Michael. Stay tuned for Washington Watch. It's coming up next. Good night.